We're here this evening for the meeting of March 3, the Planning Board, and we have a quorum, so is there a motion to open the meeting?
Motion?
Second?
Second.
All in favor? Aye. Our first item tonight is a request from an applicant on Chapel Crossing, East Village at 480 Bedford Road. This was a request to amend the resolution of approval. So we received correspondence from the applicant, and what's happening is they're very close to finalizing the sale of the last 2 or 3 units. I think it's 3 units that are outstanding. And they've asked for an amendment to the resolution that was approved 4.5 years ago to enable them to close on these last remaining units, even though they haven't fully satisfied the conditions set forth in the resolution. So they're asking for really not a waiver, but a change in the resolution to enable them to close on the last few. So is the applicant here? Representative?
Yeah, we are.
There we are.
Mr. Chairman.
Mr. Clifford?
Cooper, was that me?
Sorry, I got to see you, that's about it.
It's okay.
Sorry.
No problem. Good evening, members of the board. My name is David Cooper. I'm a partner with the law firm Zarin and Steinmetz, representing the applicant Toll Brothers. With me tonight is Greg Otis, the senior land development manager for the project. You're correct. We are here asking for a slight modification to the site plan approval in asking to move the conditions 58 to 62, the deadline to complete those from the final issuance of a C of O for these last 3 units to the closeout of the filling and grading permit for this overall site work. The reason why is because we're holding up the purchase of the last 3 units, and we didn't want to keep those purchasers in limbo until the site work conditions can be satisfied. And so what we're asking to do is to move that to the grading and filling permit closeout, because the town currently holds over $3 million in bonds for that work, and so there's still a hook into the applicant to make sure that even though once they get the C of Os for those residential units, they're still coming back to the town to making sure that they comply with the remaining punch lists. I know Greg has been working with the deputy town engineer, Mr. Silly, on closing out the remainder of the punch list, and I'm happy to turn it over to Greg to talk through that process. But ultimately, we're just asking from the planning board perspective, to move those 5 conditions to the grading and filling permit.
Yeah, thank you, David, and thank you, Chairman, members of the board, and town staff. We feel that we are very close to completing those final resolution conditions, as well as the deputy town engineer's final punch list. Thank you, Bob Cioli, multiple Bobs here. Thank you for taking the time. The deputy town engineer and I have an excellent line of communication. I can't thank the town enough for allowing him to provide as much time as he has to talk through all the remaining items. As he eloquently put in his memo to the board, you can see that we are on his punch list. We're about 29% complete. We're approximately 42% complete on items that have been submitted that are still under review. Some of those items I do expect closure over the next week or so from our side. And then there is approximately 29% of the items to be submitted. This is, as we know, this has been a challenging winter that has prohibited the closure of certain punch list items. And we are respectfully requesting that the last CO, the last homeowner, is not affected by, call it the business between Toll and the town. I think we've been a very good developer over the last 3.5, 4 years with the town. I think this project has been performed very well with the town. I think it's an excellent community that has been established, and we look forward to closing out all the items with the town. In the overall scheme of things, I see the water and sewer dedication process occurring through the town, likely towards the end of April into May. So we are, approximately about 2 months out on our side from completing all items. And the latest update that I've received is that the last building, consisting of 3 homes, is ready for their final CFO issuance, plus or minus a week or so. We are here to respectfully request that we are able to move these conditions, incorporate all of the deputy town engineer conditions over to the closeout of the filling and grading permit. And thank you again for taking the time to hear us on this matter.
Okay, thank you. Sabrina, did you have any thoughts on this that you wanted to express?
Mr. Chairman, I don't really have any thoughts. It's really Bob Cioli. It's his project that he has most of the comments on, so I will defer to him.
Okay. Just giving some context on this to set, at least from my perspective, some context for board members. There's mention of security with the bond and that we are holding bonds. However, I will tell you, based on my professional experience, at this point, holding bonds as security is pretty close to illusory. Because at this point, were there to be a claim filed against a bond at this stage, the surety will never pay. The surety will never go out and get, another contractor. They will contest this, as will the applicant, and they should. It's a reasonable thing to do. So I don't really look at that as, it's something that was very important when it was first done. It's still important to hold, but I don't think it's something that really is, something I would consider a carrot for the applicant. I guess my perspective on this, having been around this application for a long time, is these terms and conditions are not a surprise. They were negotiated after many years of negotiation and dealings and hearings, and they were approved 4.5 years ago. And as recently as September, the deputy engineer provided a lengthy checklist of items to be completed. It was a menu, a mapping of getting to the finish line. And I know we've had bad weather, but a lot of the stuff it really is not weather related. I'll let Bob refer in terms of what he thinks is really left here to do. I think this resolution could have been drawn up so that all of these things would have been done first before any COs were issued. But we didn't do that. We worked with the applicant, as the applicant has indicated. I think it is a great project. I think they've done an excellent job. They've been great partners. But they chose a route to move forward with the sale of the homes for, good commercial reasons. And from our perspective, my perspective is to the neglect of some of these items until the last minute. Now, we got caught here. I think, frankly, they got ahead of their schedule, which is good news for them, good news for the town. But I know we're talking about, at this point, 3 homes that may not be sold, or they're requesting, waiver on this. Meanwhile, we have 90-plus homeowners in there in these units, and an HOA, which in theory could be left to hold the bag to have these things completed, or have them completed in a manner that the town approves. So it's not just getting the stuff, in my opinion, sent in. It's also a matter of doing the field work, the inspections, the as-builts, and getting it to the point where it's approvable. So you hear from Bob in terms of what that process requires. And I think the takeaway from my perspective will be, we're not in a position to grant, I'm not in a position to change the resolution. Now, whether or not we want to grant relief at some subsequent point before everything is fully buttoned up is something for the board to consider. But I don't think it should be at this point. I don't think there's any reason for the town to give up its leverage in terms of getting these things done, which could have been done years ago. I don't think we should be risking the town's monies. I don't think we should be risking the other property owners and the HOA, getting them involved. I'm not suggesting in any way, shape, or form that would be the expectation from this applicant. I don't, it would be just the opposite, in fact. But nonetheless, I think we have a responsibility to the town, to the HOA, to the other people up there, to make certain that this thing is done correctly. And I think you'll hear from Bob that we have never done this before. We have never, in all the years of working with subdivisions in this town, we have never, at this point, moved things around to the extent that we would grant COs and not have these kinds of things finished. So that's my take on it. We've had extensive conversations, but I think it's important to hear from Bob because he can tell us some of the technical issues and some of the things that are really required. We've had conversations about this. I know you'll hear about 29%, 42%. That doesn't necessarily give any weight to the importance of the issues, some of the issues that need to be completed. Some of these are administrative, and they should be able to knock them out very, very quickly. And but some are not, and some may take some time before the inspections are done, the as-built are submitted, reviewed, and approved. So it's not a matter of just the applicant submitting them and beating some sort of time frame and having the documents submitted, but they've got to be reviewed by staff and approved and forms approved by council. So it's not as brief a process at this point to get it to the finish line. Can we help them get it to the finish line? Absolutely. Would we like to do that? Absolutely. But we're here to help, but at the same token, it seems to me some heavy lifting has got to be done and expedited by the applicant. Now, based on experience that we've had with this application over the years, there have been times where an applicant has needed stuff to get done, and we have worked very, very hard. Greg was here for some of those times where we worked through the holidays, special meetings, special public hearings, staff working around the clock, applicants' staff working around the clock to beat certain deadlines. On the commercial side, if people recall, we even worked and set up a TCO so that they could begin opening even though things weren't completely buttoned up. So we have a history of doing that, but from what I understand, TCOs are not permissible for residential occupancy, so we can't do that. But in any event, Bob, there's your entree. Sorry.
Yes, thank you, Mr. Chairman, members of the board. Yes, to just agree with Mr. Kirkwood, in my experience with the planning board over the last 17 years, we've never modified a resolution to waive that certain condition about all these items being required prior to the last CO. The only time we've done that is to give the applicant temporary COs. We did that with the retail section in Chapel Hill Crossing, but that's the only time we have done that. So anyway, what I did was I just really went through all of the punch list items just to give a bird's eye view, 5-mile look of what's done. Everything that's been completed and approved, about 29%, 9 out of 31% of punch list items submitted currently under review, deemed complete, about 42%, 13 out of 31. So I'm going to start. There's no sense in me going over the ones that have been completed. They're done, they're good, they're approved. I sent Greg all the confirmation on that. I'm going to start on the items that's under the heading final CO punch list items that have been submitted and currently under review, which is 9 out of 31. Just for the board's information, EC1, EC2, EC3, EC4, EC5 are under the auspices of Mr. Corelli. I can let him speak on this real quick to see what his opinion on these are and how much farther there is to go to the finish line, Dennis. So I'm going to turn it over to you real quick, if you don't mind.
Okay. Yeah, so just so we're clear, and you know, I met with Greg on site multiple times, and I think from the, we'll call it the field work perspective, I feel that that's completed. I'm just waiting sort of for administrative completeness with respect to as-built and certification from a registered landscape architect, but to my knowledge, there's nothing else that needs to be installed. The walking trail was in, the trees as designed were in, the additional replacement trees based on field calls were provided on site, and we co-located where those should go and best serve not only the HOA, but one of the neighbors who I felt, you know, should be shielded even further from this. So that's all been done. So I just wanted to make that clear, because I know you look outside and there's a ton of snow on the ground, and that's not affecting anything that needs to go forward. So I'm just about there. I just need to review submission at this point.
So is it fair to say that the items that you still have to work on, are basically desktop issues and
Yes.
administrative?
Absolutely. Thank you.
Yeah, I mean, how long do you think to when you'll get through the desktop portion?
When I receive it, I can start reviewing it.
Is it not, it's under the heading that they've been submitted. Have they not been submitted?
I reviewed a draft
Okay.
map, provided some comment with respect to the as-built. And I know that I did meet at one point on site, the landscape architect who I think was gonna provide, you know, the letter. Because what we discussed was all the trees, you know, have like designated numbers, and, you know, there needed to be additional trees that weren't part of the original plan. So I said, I think that would all be best captured in a narrative in the letter, and not, you know, don't dot up the landscape with respect to the as-built. So that was
So they've completed the
last
work,
round.
they've given you some stuff, and then you're waiting for this post-site visit follow-up documentation.
Yeah, after I guess a round of comments,
Yeah.
next submission. That's fair.
And the applicant was gonna say when they think they can submit that? I didn't mean to cut you off.
Yes, I expect that submittal to occur as early as this week for Mr. Corelli.
Okay.
Good.
Can I just follow up on that? Just, Greg, earlier you said you thought you would have everything wrapped up by middle of May. And then David's letter says April 1st. Are you guys talking about wrapping up the same things, or are those two different things?
Yeah, I think our challenge is really just gonna be the water and sewer dedication as that makes its way through the town. Generally speaking, on the water and sewer dedication, Mr. Cioli has asked for some additional information from the Department of Health, which we are actively working on, as well as an amended easement as well. Those are, I think, the two highlights there. So I think that's going to be the kind of the final process here. So depending on how quickly we can get the feedback from Department of Health, and work our way through the town with the dedication process, you know, I think that is a manageable time frame right there.
Okay, so 2 months.
Yeah, and that information came to us after my letter went into your board, so.
Okay, no worries.
Okay, can I continue with the?
Yes.
Guys, Chairman?
Yep.
DTE 1 up to DTE 5 are actually the conditions in the resolution of major concern tonight. Conditions 58 to 62. And to Greg's point, these are all items that are going to require legal review from town council. It's going to require the town board approval and some going back and forth with the attorneys on the revisions to some of the easements. So I think you guys figure it's going to take about 2 months, Greg?
I think so, Bob, yes.
Yeah, I think that's fair. So that's DTE 1 up to DTE 5. Then we get the DET, so I'll go through item by item and let you know my opinion on how big they are, how small they are.
So
DPE
let me,
six-
Bob, let me ask you a question. Is that a 2-month running time after we receive it? Because looking at the schedule, they're suggesting that it's going to be submitted on or about April 16. So is it 2 months from April 16 after you guys receive it?
I would have to say so, because that requires town council, it requires to get on the planning board agenda. There might be some tweaks when we get it back in from him, so I would say 2 months, conservative.
Well, Greg, correct me if I'm wrong, but we did submit
Yes.
initial drafts, right? This is just tweaks to the initial drafts?
Yes,
Well-
you submitted all the
Yeah.
maintenance bonds, and I think council, you're talking about the maintenance bonds, right?
No, I'm talking about the draft easements themselves, the actual language, yeah.
Draft easements for the comments I had to revise the easement because of the water main, is that what you're speaking of, David?
There's a couple, and not to confuse the situation,
Okay.
there's a couple things that are in queue with Bob relative to the issuance of these letters here. So we could talk about the specifics, but yes, the maintenance bonds, all the drafts are in for the town's review and comments. I think that's primarily, DTE 2 all the way through DTE 5.
Mhm.
So that those are in the town's possessions now. So what we're working on with Mr. Cioli is DTE 1 and addressing the comments on the water and sewer dedication itself.
Right, but there were things that had to be done that I sent to you, but I'm just thinking out loud here, guys, so the board knows. I think to do DTE 1 up to DET 5 to get everything done, I'd say between 1 and 2 months,
Agreed.
okay? DTE 6 is really just an inspection by Terry to go out there to take a look at it. I think we got warm weather coming in next week. That's not a big item there, Chairman. DTE 14, he did submit the actual stakeout map, and it was 40 iron pins and 26 concrete monuments. I just have to send Terry out there to have him take a look at it. That's not a big item. DTE 17 is basically just a notice of termination being signed off by Jeffrey. Once we have confirmation from Terry, which is DTE 6, that's good. So I don't think those items are big. The biggest item to hold things up in this one list of items is the dedication and all the maintenance bonds, if that makes any sense.
What is required in order for you folks to be in a position to approve it? Tell us about what has to be done in terms of the as-built inspections and reports.
Well, I didn't get to that one yet, right? I'm just talking about the ones that have been submitted, right?
Okay.
So I'm going to go to the next one. Next series of items are the final CO punch lists that have been submitted to date and deemed incomplete. We just went over those, right? Let me see, wait up, what am I doing here? Yeah, right, DPW 6, I'll go through them right now. That starts on the bottom of page 4, just so everyone's information. Final accepted as-built. Once the as-built have been accepted, DPW 6, that's something they have to give us in all AutoCAD files. That's the reason we need that, is so we have a town GIS system, so we can download that into that. I think Sabrina worked with Bart on that. That should not be a big item for them to get. DTE 7 is a big item. This requires them to submit the as-built topographic survey. We have to review it. We have to make certain that the slopes are okay in the roads. We have to make certain that the easements are within the limits of the infrastructure they put in. We have to look at the basins to make sure the basins were constructed properly. So there is some back and forth on this item. It is the biggest item in here. And in my estimation, things like this can take between 3 to 4 months to go back and forth with 2 or 3 iterations. They may need some regrading out in the field. In my experience, I've never seen the stormwater basin put in correct the first time in all my years of looking at basins over the 4 or 5 subdivisions. So this is a big item. That is a big item, no doubt about it. DTE8, that's something the engineer will look at the as-built, and I believe, Greg, that's Mark Gratz looking at these right now. That's a certification letter, that's work he's doing. That takes some time. DTE9, provide an updated stormwater report. That's going to be their consultant. Greg, chime in anytime. That's going to be Mark Gratz doing that.
Correct.
DTS Provident. I don't know what the status is on that. We have not received it yet. DTE10, that's an inspection report, which is quite comprehensive. They have to go out there, the consultant, DTS Provident, they have to photograph documentation of all the stormwater, make sure everything's working as designed, and make certain there's no maintenance required as far as sediment removal. So that can take some time as well. I don't know the status of that. Greg?
Yeah, actually, yeah, Bob, that one, you should have that within a week's time frame.
Okay.
So that is a big one, prepared by DTS Provident. And that one is basically ready for submittal to you for review.
Very good. DTE 11 is additional stormwater management as-built. So DTE 7, Mr. Chairman, and DTE 11 are the two biggest items in my eyes, which takes some boots on the ground, takes some iterations in the review of it, and it may need some actual field work to be redone to make certain it matches and complies with the approved plans. So those are the two biggest items, which could take 3 to 4 months. DTE 18, certification of construction compliance. That's a letter from their engineer, have to reviews all the as-builts, payment of all outstanding review fees. That's not a big deal. That does not take much time. DTE 20, Greg, have you received anything from the building inspector?
No, I have not. And this item was requested over about 30 days ago from the town.
Mm-hmm. Well, I would try to call them up and meet with them to get those items. But, Mr. Chairman, that's my take on the items that have not been submitted and the amount of time and the big items that do require a lot more work than just desktop review. And that ends my comments.
Okay, good. Questions, comments from board members?
Have you commenced the as-built process yet?
Yes, we have. Yes, we have. The as-built is approximately 80% complete. And upon completion, copies are provided to Mr. Scioli, as well as to DTS Provident, our civil site engineers, at which time they'll review and provide the appropriate certification letters. And I was just thinking of one side comment regarding the chairman's comment about potentially leaving these items to the HOA. I just want the board to know that we're legally obligated through the offering plan by the Attorney General's office to perform all of these items for the HOA. So it is an obligation that we need to complete satisfactorily, and it is one that we will stand up to. And also, as you had mentioned, Mr. Chairman, about the outstanding bonds, those outstanding bonds do have costs to Toll Brothers, and those are bonds that we need to work with to get released from the town. So these are items that we need to correct and address as soon as possible, and we look forward to continuing that process with the town. And as mentioned earlier, we're simply requesting not to mix these new homeowners, town residents, into the mix of this business that really is attached to the site, and our request to tie it to the filling and grading permit closing.
Are you under contract to sell these last 3 homes?
We are. We're expecting to close on those at the end of March, early April. The last building consists of 3 homes, and all 3 homeowners are ready to take occupancy of those homes.
Okay? Any questions, thoughts?
I'm just thinking.
Okay. One of my thoughts would be, on this is, not to just leave this out in limbo, but to work with the applicant and, as we've done, by the way, previously in the commercial side, work with the applicant and set up a very tight time frame, maybe every 4 weeks, maybe every 6 weeks, whatever's comfortable for the applicant. And working off of the punch list and making progress on the punch list and getting an updated report, let's say in a month, 6 weeks, whatever it might be. And before we even do that, I should really ask the applicant, since we have the town folks here, is there something, we heard something in here that something was submitted, for example, to the building inspector. Are there any things in here where the town is holding you up that we can try to express things moving it forward? Other than just the normal, you're going to be submitting these things and understand that we're going into the building season, we're going into the busy season. You're not the only application that we have in this town. And there's a queue and people also have reasonable expectations throughout the town when they submit their applications. So from what I understand, things are picking up. There's going to be a backlog of new applications. So, but is there something that we can do, is there something that's holding up the applicant that we can try to move along faster? I think what would be very helpful is to hear from the applicant on that issue, but also for all of us to have the applicant set up a checklist and just have a progress report. Maybe it's weekly, you send it into staff. And then we plan to pencil you in to meet in a month, at 6 weeks, whatever's comfortable for you, and see what we can do at that point, where we are in terms of how many more items have been completed, what has not been completed, the reason why it hasn't been completed. I will tell you that not to give up on, give up Dennis's secrets here, but in a conversation earlier today, Dennis's position on his items was, I don't know why it hasn't been done. It wasn't something that was very tricky. It's not rocket science, and for whatever reason, it wasn't done. But it seems to me that those items are going to be very easy, low-hanging fruit, and the applicant will be able to get those in right away. The things that are tougher, as Bob has outlined, it seems to me that sooner than later, it's important for the applicant to marshal the appropriate staff and technical people, surveyors, whatever it is, and get them going ASAP to move that forward. Those are more difficult and perhaps even more important. And I recognize that you have an obligation to the HOA to complete things, but if that's the problem. If it's perceived by the HOA that you're not moving along quickly enough, I mean, that's the kind of stuff that generates difficulties and problems. And one of the things I want to absolutely avoid is any expense to the town getting involved in litigation on this. It's just crazy. Let's get this across the finish line and get you guys set and get the new folks into their new homes. So that would be my proposal. You guys come back to us and tell us what you think is more comfortable. I think reporting on a regular basis to staff would be very helpful, but perhaps we can pencil you in for, a planning board meeting a month from now, 6 weeks from now. The problem is that, again, we're pushing up against the date for a planning board meeting a month from today. And that, what's the submission date on that, Felicia?
Well, for the April 7th meeting, the submission deadline is March 16th.
Right, which is just next week.
Mhm.
So it's
Yeah,
very
Mr. Chairman, thank you. Yeah, I would absolutely thank the town for the opportunity to come back to provide a progress report. I do not think there are any issues with the town staff progressing items. Actually, to the contrary, they're extremely helpful. And I'm able to ask questions of Mr. Cioli pretty much any time. I believe we have a great line of communication, so we would definitely be open to coming back to the board. I thought possibly the April 17th meeting to continue to provide status updates. And at which time, you know, I think Mr. Cioli could also provide his feedback too. And so that
Greg, I
is
think that would be
definitely.
April 21st. I mean, not a big deal, but just.
Or was
yeah.
it the March
Okay.
17th meeting you were talking about? I don't.
Did you mean April 21?
The April 21, I'm sorry about that.
Yep, thank you.
Mhm.
I think that's a reasonable way to try to get the applicant through this and finished.
I think also, if you're not complete, status actually of the as-built, I mean, what Bob and Jeff say, as far as, are you on the 95-yard line or are you still on the 80-yard line? Or,
With the initial submittal, we're about on the 90, you know, 90% done,
10-yard line, yeah.
10-yard line, 10-yard line.
Hey, I thought I heard you guys say that of all the things on the list, there was only 2 or 3 things that had a really long window of work that were months. And mostly everything else was short, administrative, and you thought you were banging it out in the next few weeks. And with 3 closings, you said possibly in a month from now?
No, actually, we're looking to request the CO final inspections from the building department within the next 2 weeks.
Oh, okay, so it's even quicker.
It's even quicker, right?
So get the surveyors out there on the as-built.
The field work has been completed, and they're just finalizing the plans. And again, we feel that it is, you know, very obviously within the next couple months being complete here. We feel that, you know, these, you know, the last homeowner should not be affected as the other 90 homes would have had the COs issued. But to single out one town resident for this issue with their new home that they're looking forward to moving into, we feel that we're requesting that the board consider this application.
Right, okay. But does that sound like a fair schedule then, to set up something where your team reports in at whatever regular time you feel is fit, and then we'll pencil in April 21, and hopefully we'll have a good progress report from you. Again, telling us what has been completed, what has not been completed, and if you would, let us know what the obstacle might have been or continues to be that prevents the completion of the last couple of items. I'm hopeful that by the time we meet again, you're at the 97% or 100%. That's probably unlikely, I guess, with some of these as-builts. But in a position where, you know, we feel far more comfortable to move forward and figure out some sort of solution for you. Is that okay?
Sure.
Stuart, is that okay? You're okay with that?
Yeah, I'm good with this.
Okay?
Yep.
So I guess this is just, what are we considering this? It's just an informal hearing, right?
Yeah.
So, nothing special in terms of notice. And if something comes up and, you know, the 21st doesn't work, but you just have to do it another 2 weeks from, fine, we'll just, you know, make the change, whatever it is, we'll pencil it in. If for some reason lightning strikes and you really are in very, very good shape and you want to do it in the first meeting of April, we might have an opening for you, and if that works, we'll work with you to try to get you to the finish line even faster. All right? Great. Okay, well, thank you.
Thank you, Mr. Chairman. Yep.
This is very difficult when there's different pieces that come with different dates. Okay. We do not have a second item. Apparently, the application has been removed from the agenda. This was for Supreme Homes LLC on Tanglewood Road. So we will hear that when staff has received the completed application. Apparently, it wasn't complete. And so we'll move on to our next item.
Hey, good night, Mr. Chairman and the board.
Yep, good night.
Good night, Bob.
Yeah, take care.
Good night.
Thank you, Bob.
So our next item is the Racine Reamer, 93 Pines Bridge Road, application for a site development plan.
Good evening. I'm Jim Manicarico with Cronin Engineering. Glad to be here. So yes, our application, well, let me give you a little bit of background. Tom Racine, who's on the screen up there, he was the owner of the property when the pool and the patio were installed. Mr. Brian Reimer is the current owner of the property. And they, you know, there's obviously they're still tied together through some escrow money between them for Tom to finish this up and give clear up the building permit for the pool.
There's nothing like an escrow to solidify friendship, right?
Yeah, exactly. There was a in-ground swimming pool installed by Tom. There was a permit issued for that. At that time, there was no thoughts of patio around it, so it did not require any drainage mitigation because it did not go past the 1,000 square foot mark. In the meantime, a patio was installed. I will note that the entire pool and patio were not installed beyond the clearing and grading limits line on the lot. They were all on the correct side of it. There was, when we submitted the as-built, there was a small portion of the patio in the side yard setback that we had to go to the zoning board for, and we did, and we received the variance, 8-foot variance for that into the side yard. There was some drainage mitigation, in the form of Cultex installed by the contractor. There were 4 Cultex installed. They were beyond the clearing and grading limits line, and that's kind of how a lot of this started. We made an application last year, and it was decided that the drainage wasn't to this town staff liking. So we went back and we did some recalculating. Well, in the meantime, we had Jeff had provided us with additional impervious areas on the lot, some of them which were done prior to Mr. Racine owning the property. And he asked us to include them in our drainage mitigation, which we happily did. So we now have submitted a plan that proposes an additional 10 Cultex. They are obviously beyond the clearing and grading limits line as well, just because that's the only spot on the property pretty much to do it in. I should mention that not part of the pool project, but at some point, Mr. Racine expanded the driveway, the asphalt driveway on the north end of the property. About 777 square feet of asphalt that was added, and that we've mitigated, that we've designed our drainage for. 157 square feet of that asphalt was outside of the clearing and grading limits line. And then I think there was another maybe 500 some odd square feet of that was beyond this clearing and grading limit, which was the Cultex. So this backyard is essentially grass beyond the pool and patio, almost up to the property line. There is a fairly substantial planted and mulched bed along the west property line adjacent to the golf course. I did submit some historic photos of the property all the way back to 2000, I guess prior to the house even being built. There were some pine trees along that property line, which eventually were removed. I think there was a willow tree just north of the patio and pool that was removed. There is a large pine tree in the northwest corner that still remains, and many trees along the southern property line with the residential neighbor to the south. There is no residential neighbor to the north immediately. It's basically a drainage easement and course that takes some of the drainage from Pines Bridge Road and brings it down to a culvert that eventually goes through the golf course and probably into one of their
Is that lot to the north view part of the golf course, or is that a private lot?
that is Town of North Castle's lot. There's a strip there.
No town.
Yeah.
Oh, okay.
Beyond that, I'm not sure.
Gotcha.
So the golf course is all the property to the west though. So, before we made the resubmission,
This is all town property.
discussions with town staff, it was suggested that we ask for the clearing and grading limits line to be adjusted by the board. And so what we did was we kind of did what we thought made sense and adjusted it pretty much up to the property line in the rear and close to the property line to the north. It's essentially all grass now.
Can you speak to the wetland issue and the
Sure.
wetland buffer issue? I think that's important
Sure.
for the conversation.
I guess during, I don't know all the history of it, but I assume that during the subdivision of this land, at some point, there was a wetland, maybe to the north, there was a 100-foot buffer line that was on the filed map, that everything was outside of, believe it or not, pool, patio, driveway, everything. That has obviously since changed to 150 feet, but Dennis did provide a memo. Some of the stuff that I honestly was not aware of, I guess it was looked at some point in 2021 by a wetland consultant, and it was determined that there is no longer a wetland there. So I believe Dennis's recommendation was to maybe amend our plans to show that there is no longer a wetland buffer on our property.
Good, thank you.
Sure.
Dennis, do you want to comment?
Thank you, Mr. Chairman. So yeah, the first thing I just mentioned, because I know why you had to check the seeker form. I just bring up the cultural resources because if you think wetlands is a 4-letter word, if there were truly cultural resources, that's 4 letters capital. So I decided just to provide the map that shows where those resources are, and they're obviously not near the property. So that was kind of just to check that box. With respect to the wetlands, yeah, you made it convenient by basically submitting, all of the aerials, which kind of provides, the history of, the property and then its, immediate surroundings. So, at first, the whole reason, I guess, to go out and just investigate, because, I didn't think there were wetlands on the property, but, the buffer obviously was influenced off-site.
Offsite, right.
So, and now it's 150 feet and, back to inconvenient truth, so it's like, okay, well, considering that the town land is adjacent, you have permission to go on that land, you should hire someone that, and again, we didn't do, I didn't ask or request to have a delineation done of that entire
Right.
piece, just, proximal to the property line. And it was interesting that, I guess Mr. Schmidt didn't, find wetlands there, and the closest wetland that he found was, back on the golf course, so I, did some field confirmations, and it was, an odd, situation, cause, you, like he did, you beeline to where all the hydrophytic vegetation is, and I, one spot I didn't pick up hydric soils, another spot I got some weak modeling, and I'm like, this is off, like something odd is going on here, you just expected stronger redoxamorphic features, that's the word. So, I said, you could put the pool in, I'm not, there's no wetlands buffer issue here.
Right.
And so then, as time went on to this, and now we're looking at, what the filed map was. It's interesting to look at this property and then, the two adjacent properties that were developed. Those lines appear to just be drawn, I don't know, it has some uniformity to it, it kind of goes towards the back line, and then here, you got a sharp bend because presumably, there's the wetland buffer there in that corner, so the clearing and grading limit line certainly took a hard turn. So, it's difficult now from that perspective to say, okay, so if the wetland is gone, then, there's no worries about incursions into a buffer. But if some of that clearing and grading limit line was actually predicated on that and the wetland's not there anymore, and I'm, if you ask my opinion, I think because when the golf course went in, they totally changed the hydrologic patterns there. They just, there's, either they facilitate drainage, I'm even looking at the very first aerial that you submitted in 2000, if you go to the rear corner of the property, which is kind of like that northwest corner, there's little rivulets there, it looks to me, like, that, those are not there now. Now it's golf course and a paved golf cart, access way. So as far as the wetlands is a non-issue at this point, at least with respect to this property, there is no buffer. If there was another reason for the clearing and grading limit line, then I just, included to sort of in summation of my memo that, that's kind of the exercise that you would sort of go through, the avoid, minimize, mitigate, and, it's difficult now with this property to potentially, mitigate for all that. But again, if the influence and the reasoning and rationale really was wetlands driven to establish that line, it's not relevant today. So that basically what I was trying to, sort of bring forward, and I guess that, has to be obviously a detail for the board's consideration, that if we're gonna consider amending the line, the wetlands is not a factor at this stage.
Okay, thank you. Sabrina, do you have thoughts on this application? I forgot to call on you.
Just for the board's information, it's a type 2 action under the State Environmental Quality Review Act. My one comment was, the application, there is a 777 square foot encroachment over the clearing and grading limit line. There is a new line drawn on the plans, but it's something for the board to consider. Dennis has addressed the wetland buffer. It is zoning compliant. There was variance for an 8-foot side yard setback that was granted by the Zoning Board of Appeals, and all of the coverage calculations are within the maximum allowable limits.
Great, okay, thank you. Jeff, you had
Yep.
some comments? Jeff, you had some comments?
Yes, I did. So I was on looking at my comments and I had to go back to the Zoom to unmute myself. So yeah, the previous comments that we had for the applicant were generally satisfied. There is, one of the things that we do need to verify, which I don't think was done in the initial, but the new Coltex, the new infiltrators that are being installed, we do need to make sure that there was no perk or deep testing. So we need to make sure that if we either have to view the soil to make sure that it does perk, but at minimum do a deep hole test to make sure we have separation between the bottom of the infiltrators and either groundwater or bedrock. That's the only previous comment that we just need to kind of hold on to, but generally, previous comments were satisfied. There are a couple of new comments. Most of it has to do with just, we'd like to add a couple of things to the drawings, just to memorialize it, some notes, things like that. The only, intermediate change would be to add, there's no pretreatment for the stormwater, so we just requested some pretreatment be added prior to the infiltrators, but generally nothing, I don't think it's anything that's too much to overcome. Generally minor.
I would agree.
Are we anticipating any fill to be introduced?
No.
Okay, so it's just I guess a form comment.
Just there will be crushed stone brought in, but not fill per se. But when you install the infiltrators, you have to surround it with 3/4 inch crushed stone. So there will be material that gets brought on, which is why we have the comments regarding fill that's brought on. Generally, it's really more of a paperwork thing to prove that the material that we got is clean and not environmentally hazardous.
Right, typically that wash gravel would be required for the drainage, so we would provide a ticket for that item.
Jeff, with the Coltech that's installed and the Coltech that's proposed, are you satisfied that will mitigate the additional runoff from the 776 feet of macadam that's there? That was put in afterwards?
It does. It covers 100% of the coverage without any reductions for infiltration, which is perfectly acceptable. Like I said, the only thing we need to just verify is that the soil does perk. We do get percolation because we can't have the water go in there and then it'll just sit in there and it won't go into the ground. And the second thing is to verify we have the separation distances between groundwater and bedrock.
Right, and just to touch on that for a minute, I wasn't the engineer back then when the Coltex that were installed were put in, but I've seen pictures and I don't see any problem with that happening. And we're obviously just adding them onto the end of it, so I don't see that as an issue, and we can provide that.
Okay.
Yeah, the only risk is if they weren't able to achieve percolation there, or weren't able to get separation distance between the bottom of the Coltech and groundwater or bedrock, is the system would have to be, they might have to go with shorter Coltech, so it might have to get moved or something like that. But that's a risk that if they choose to accept that risk, that they may have to change the design. That's fine. I don't have any concerns about it. Coltechs there are Coltechs there now, but just wanted to put that out there.
Okay, good.
I've been there in a rainstorm. They seem to be functioning. What's there now, fine. I don't see any issue with runoff. As I said, there's no downstream neighbor, residential neighbor. I'd be more concerned with doing something like this without all the information. But I really don't see any issue with it.
You got the golf course wicking water away, I'm sure that'll help.
Right,
you.
yeah, exactly.
Right. Well, it seems to me that the clearing and grading limit line might have been drawn because of the wetland buffer issue. And it seems to me if we don't have a wetland buffer issue, I don't see any real reason why we would not go with the applicant's proposed clearing and grading limit line, which is basically the property line. It's all grass and lawn anyway, so I don't know why we would not grant the request. I mean, Dennis is.
The only thing that would go along with that, Chairman, is they have to file an amended map with the county to get that formally amended, which I made a note, I think, in my memo about that.
Yes, you did.
Right, so so I can be clear on that, so if you see with my memo, I did attach, but I guess that was the subdivision map, which obviously has, so you guys are gonna file a map and it's just gonna be a broken line for your parcel. And then I guess that artifact of wetland buffer of 100 feet is obviously just gonna continue for the other.
Yeah,
Because you're not changing, right, subdivision map doesn't change, it's just gonna be your parcel.
I assume we'd be just filing the survey?
Yeah.
And my plan maybe together with the
It's just-
survey,
it's
with the
just
actual
yours,
property survey?
yeah.
I'm gonna have I'd have the surveyor, add the new clearing and grading limit line and remove the
Right.
wetland line from the survey.
Exactly, yeah.
And update our note, referencing that survey, and then we could file both plans, together.
Yep, yeah. The
Jim,
puzzle pieces
Jim,
won't-
we'll have to coordinate on that. It doesn't need all that extra information. It doesn't need all the survey information. It doesn't need all your, so the file map is really just, it's gonna be boundaries and lines, but we can coordinate on that, you know, let's, down a little bit.
Great. Does that sound reasonable, to everyone?
Yeah.
Okay. We have to go to public on this, I found out today. So, we'll schedule a public hearing as soon as we can. There are no more materials that we really need for this, so we can schedule a public and maybe, if we so desire, direct staff to propose a resolution so we can do a one and done next time we meet. That sound reasonable? So is there a motion to set the public hearing and to direct staff to drop a resolution for that?
Motion.
Second?
Second?
All in favor?
Aye.
Okay,
Thank you very much.
yep.
Appreciate it.
Good night.
There was bound to be a happy person leaving here tonight.
Thank you, everybody. It's been a long ride. Thank you. You're well.
Law of average, huh?
Thanks, Sabrina.
You're welcome. Have a good night.
Thanks.
Stay
Jeff.
warm in Florida.
We will. Thank you. Take care.
You're telling me that this lot is all owned by the town?
Apparently, yes. I think it was a drainage lot.
Is the land so this guy's constantly planting over here. I was like, oh, that's
So you thought it was a nursery?
I thought the nursery's across the street. And I thought that was his because I always see him over there planting.
Our next item tonight is a referral from the town board with regard to the proposed battery energy storage system legislation. So we last heard this back on February 3. I don't think we have anything formal, so it's really a discussion. It's a referral to us by the town board for a law that we proposed. And I think we discussed it last time with regard to tier 1, tier 2, tier 3. Tier 1 is designed to be permissive, and tier 2 and tier 3 currently in the law is proposed to be prohibited. So that's where the proposed law is. We left it with Jeff to get on a plane to Phoenix and to write all kinds of information for us. And by the way, did you get the note?
SAB?
Yes, SAB, okay. Good. Anyway, I don't know where you wanna pick up from there. Is Tom on? Tom DePaul?
Mr. Chairman, he actually could not attend tonight. I do have the capability to text him with specific questions. He does send his apologies, but he has a personal matter that he's dealing with.
Okay, no problem, thank you. So anyway,
If I could, I just wanted to kind of set the groundwork for the board, and just remind you that this is a legislative referral from the town board regarding a law that is presenting a prohibition on tier 2 and tier 3 battery energy storage systems. The charge of the planning board is to decide, number 1, do you agree with the prohibition? Or if you don't agree, why not? Or if you agree and there's a but, that is what the town board would like to know.
And the prohibition is forever until the law changes?
The prohibition is a law that will be promulgated that can be subject to change later on.
Okay, but by legislative change.
Right, there's
It would
no-
need to be legislatively changed.
Right, there's no sunset date or expiration date written into the draft.
And do the zoning and planning boards have the right to, after the law, if the law's passed and applicants come, do the zoning or planning boards have the right to, Relieve it?
grant
No.
relief? No,
no, okay.
no,
No.
Okay.
there's no variance
So
from it
this
or
would
anything like
be,
that.
this would be no, if it gets passed, no 2 or 3 gets done, period, until the board has a new law.
Right.
Okay.
if,
If,
Right.
yes.
So it's a
That's
pro,
it.
it's
It
a
would require-
prohibition without a license or a permit process.
Gotcha, okay.
And last time we heard, Jeff came up with a couple of issues in terms of possibilities with regard to tier 2. I think tier 3 is pretty clear. My concern on it is probably, I don't have the ability to have concerns on the science. But one of the concerns I have on this is that this is couched as, of course, a zoning regulation, but it's one that's going to be based on, should be based on, I believe, not just because we don't want it, but really on valid environmental issues. And I'm not quite sure, my recommendation would be that the town board make sure that they've covered themselves and they've gone through the proper, I don't know if a formal secret process is required, but some sort of process to make certain that there are good reasons for the findings that they've made, leading them to say there cannot be any tier 2 operations in the town. Now, it seems to me just saying we want to preserve our residential feel and nature may not be sufficient. It seems to me that there should be more of a basis behind it. And Sabrina has told me that there has been, they've done a lot of work on this. They were charged, the staff was charged with doing a lot of research. But it seems to me that that should be formalized and made public in case there's some sort of challenge. And then whatever those findings are that led to that conclusion, as far as I've heard, the only things that we've considered are commercial, perhaps commercial and clustered or density issues for tier 2. But it seems to me that we have the potential of other tier 2 applicants or interested parties, say the Sunshine Hospital over on the west side of town, perhaps the schools. I know that, I'm jumping ahead, Sabrina really should tell you this, that one of the things that they thought about was that it ought not to be within 500 feet of a residence, and it seems to me that some of these properties, if it's located properly on the property, that it would not be within 500 feet of a residential location.
That's a tier 2?
That's tier 2. Tier 3, I think the feeling on tier 3 is that they're just so powerful and so big that there's a pretty good feeling that you shouldn't do it, but
So
anyway.
a question, and I don't know if any of us can answer this, maybe only Jeff can.
Can't answer anything.
Okay. So I see the number thrown around of the 80 kilowatts, right? And that's the top of tier 1. And then I read in the memo, and I think you said last month that an Escalade is 200. So I'm confused.
205.
What's that?
205 kilowatt
205.
hours.
So I find it confusing, and I liked what they said in the letter that professionals are installing the in-house ones that are done properly, and then you have people driving their cars in, and a car battery could be damaged for all they know because they hit a rock, and they've got a 205 one sitting in their garage. But that's permitted, but a really safe.
So let me just interrupt here a second. Vehicles are regulated outside of town control.
But I'm asking, what's the logic for their decision? Well, who on the board did the research to come up with the 80, or who on the town came up with the research to do the 80 when we have larger than 80 driving around the streets now, parking in garages and parking on streets and parking everywhere? I just don't, I don't understand how the 200 is safe, but the 80 plus isn't. Unless I'm just missing something. And I understand the point that the town can't regulate cars. I'm not trying to regulate cars. I'm trying to understand the math.
70 to 80 comes from the New York State Building Code, actually, the fire code. They're the ones who determine up to tier 1 is 70 or 80, depending on the type of battery. It could be less. Between that 80 and 600 is considered tier 2, and above 600 is tier 3. So nobody at the town made that. It wasn't an arbitrary decision by us. It really is taken from New York State Building Code.
Jeff, I'm not pointing fingers. What I don't understand, I understand the math. I'm just trying to figure out how, if it's being done for safety, how then are the 200s safe and the 80s not? From a New York State Fire Department logic, I don't understand the logic in that. It seems to me that the cars are way more dangerous than the batteries that are installed in the garage.
I totally get it, and I would be, I see a reason to say, even we should allow tier two up to 200 kilowatt hour, 250 kilowatt hour. I don't know if we can make that distinction, but it seems to make sense that if you have a 200 kilowatt hour car parked in a garage, what's the difference between that and having a 200 kilowatt hour battery pack on the side of the house?
Right, installed
And
properly.
that, you can make that recommendation and say, we should allow tier ones and tier twos up to 200 megawatts or 250 kilowatt hours. And then, anything above 250 kilowatt hours should be, a special use permit by the town board or by the planning board or whoever. The planning board can make that recommendation that, we think the tier one, the 70 or 80 kilowatt hours too low, raise it to 200 or 250, and then above that, tier two, require a special use permit, provided it's at a residential, conditions on it. It's residential, it's for, whatever, powering a house, it's not for powering, side projects or whatever.
I mean, even the comment in the letter we got about the CHAP, that they generate more than they can store.
Right, and then there's also, well, if they're generating more than they're using, especially during the day, if they're not net metered, so it's going back to the grid, then those panels just stop producing. They only produce what's needed.
Right.
Batteries allow.
Well, Sabrina,
But.
Sabrina, you know about that, right? We get credit for all that stuff that we put back in the grid, don't we?
It depends. It really depends.
But
Okay.
first off, I want to thank Sabrina and Tom. We had a very nice conversation on the snow day last week where we went through a lot of this stuff. So I appreciate all the effort and everything that they've gone through. I didn't realize the extent and the tasks that they were deputized with doing. So after that conversation, had a better understanding. My comment first off is it relates to what Jeff just brought up, which is the New York State Fire Code. And Tom, we spoke about this 2025, where those numbers that are in the in this proposed law come right from the code. But at least my read of that section is that if you're below these numbers, this section of the code does not apply. Section 1207.1.3, energy storage systems having capacities exceeding the value shown in the table below shall comply with this section of this section. So anything below that, you don't have to do anything that's in here. I disagree with that fire code, but that's a whole different issue. As was just brought up, tier one, I think tier one, tier two, tier three have come, we've created these tiers. As a point of comparison, a Tesla Megapack, which is the biggest, right, that is roughly 30 feet by 6 feet by 9 feet tall. So it's a small shipping container. That has 3,900 kilowatt hours in there. So that's what we're, from a comparison standpoint, how big something would have to be to store 600 kilowatt hours is a lot smaller than when you compare it to 3,900 needs the whole, needs a shipping container size basically. So I do think that we should expand these numbers to allow more storage on residential properties, especially like the Tesla Powerwalls that I have. They'll only stack them by 3 because the fire code says you can only stack, basically you can only stack them by 3. But there's no reason why I shouldn't be able to have, or anyone shouldn't be able to have, a section of 3 for the required separation, another section of 3, because you could in essence use these as your instead of backup generators, right? So you're going to the one of the goals of this is to reduce our footprint, our carbon footprint. Secondly, I found out in our town code in the past, for batteries, you're not allowed to have the batteries if you don't have solar. Now I know people would put the batteries in, but don't want to put holes in their roof. So we may want to expand that conversation with the town board, having this distributed. Can be called distributed generation in theory, because if you wanted to, you can discharge those batteries to the grid during the day. Not saying that we should be dictating that, but if it allows there to be less demand on the wires that are going down the road, which reduces the opportunity for transformer fires, for increased transmission lines. I think we should be working towards that, to giving our constituents something that allows them to do that. Secondly, as Stuart brought up in his email, why are we limiting this to 1 or 2 family homes? Residents are residents, right? We just heard from Toll Brothers that this last home has is in one building, right? So is there any reason why they should be not be able to, if Toll Brothers or their HOA wanted to put those in, that we should be limiting that? Maybe there is a valid reason. I'm not an expert in the code. I just try to read what I can.
The only thing I can think with multifamily housing is that you'd be stacking a lot of them together maybe, and they don't want the density of it, right? Maybe.
Yeah.
But you
Like,
would
think
have
of
some
a
sort of
meter bank
separation
on-
requirement, would you?
Yeah, there's,
Well, like if you think of a meter bank on the side of a wall of a multifamily housing, there's like 30 meters.
yeah, they sub-meter,
Right, they may not wanna see 30 of those battery packs
Yeah.
outside on a wall. And that may be
Now,
why.
what would likely happen in that scenario, and Sabrina, Tom, and I spoke about this, is that either Toll Brothers would have their own, they would be the ones, so they'd be before the sub-meter. So they have a deal with Con Ed, where they cite something on their property, and everyone, it's not necessarily each residence gets it, but the main feed that's coming in has the battery backup in theory. Or Con Ed does it themselves, and then our board and our town board has no say over it. Because it's a public necessity,
Right.
and that trumps local jurisdiction.
The Tesla project in Millwood, does this impact that?
The gentleman who came last time brought up that they have to have batteries on site to support that. I don't know what their electric feed is, if he's saying that they're designing it, that they have the batteries there just in case if the load if all those are filled up, right, that they can't pull enough from the power line that they're gonna be discharging there. I don't recall what was in there.
Yeah, I don't remember.
But it's my understanding that there's a project that is looking to do a large amount of this in a residential area, and I mean, there's pros and cons of it.
Those are the letters we've been getting?
I tried to
Yeah.
find information about it online.
I haven't seen it.
I couldn't, there's nothing like NISO, couldn't find any, NISO is one of the power regulators in essence. I couldn't find any documents on what they're proposing, other than someone submitted something. And then there's Sustainability Board is correct in that this technology is continuing to get better. They're continuing to put additional safeguards in. Unfortunately, like most things, right, trial by error. Right, something happens, you figure out what it is, and you put some form of safeguard in there. But, my comments were that I think first off, in our code, we shouldn't necessarily be dictating some of the nuances that are in here, and we should just refer to the code, to the New York State Code. If we wanna be more restrictive, then we can do that, but to go through and have actual performance criteria, design criteria, which could easily change, and then we need to
Keep up with
we
it.
need to keep up with it. The comment that I made about the tier one, really, the chart is the minimums or the maximums before you need to follow this code. Ability to allow larger systems, and then I think we should talk with the town about our code. Should we be allowing battery energy storage systems without the solar? That's my.
So if you don't have solar, you just charge the batteries from Con Ed?
Yeah, so you can do it one of two ways. You can set it, and there's different systems. You can set it that it's 100% charged all the time. When you lose power, it discharges. Or you can set it that it charges at night when the power is cheaper, and then during the day, it discharges down to your reserve, and then it connects, and then it starts pulling off the grid.
Right.
That is more important during peak season, peak times, where there's concern about overheating of the lines. Like, there's only a certain amount of power that can come down a line.
Right.
But which if we start having these big peaks where there's issues and tripping, then the power company comes and they put a brand new line down. And when they put too many distribution lines, which is the, call it low 12 kV lines, then they start bringing transmission lines, which some of those could fit on poles, 3-phase, but then you start getting the towers that are in Millwood, which I think everyone wants to resolve. So I know with Con Ed and a lot of the utilities, what they're starting to do is find properties that are adjacent to their transmission lines and do those large stations so that they have power in essence stored closer to the demand and they don't have to run additional lines.
Sabrina, did I misunderstand from the last time that I thought currently in order to, you had to have solar to even have a tier one in this town? So that was
Correct.
a requirement. You couldn't have the system without solar. You must. It has
Correct,
to be tied in with
you
solar.
must have solar.
So I mean, I think that's a point that we should perhaps bring up to Jeff's point that why are we doing that? What's the reasoning behind that? If there are some evolving technology and alternate technologies that permit us to reach the same sort of goals, but without solar.
Especially as we get into smarter homes and smarter houses, I have to think that the design industry is gonna start designing these battery systems into homes.
Oh, yeah.
Just I can see the trend down the road. It makes sense, from a whole smart home point of living. So
It's cheaper for Con Ed to give you an incentive to put one of these in than
Yeah.
to run a new line down your block, right?
And it's a whole new
Or to
industry.
add more generation, right?
Right? Think of a whole new industry,
Yeah.
as we're phasing out some industries and new industries are being invented. I mean, this is a whole new industry in home technology. Especially, I loved in their letter talking about the microgrids and things like that, if that's really actually happening, what a great concept for the future too.
Yeah. And there's nothing to stop someone from charging their Tesla right in front here, driving to their house and utilizing the battery in the Tesla to power their house. The same thing with the Ford Lightning. I don't know about some of the other cars, but
And when you charge out here, it's free, isn't it?
no,
Oh, you have to pay? Okay.
Yeah.
No, yeah.
pay. Town makes a couple shekels a kilowatt hour.
Oh, they should.
Yeah.
So my thrust on the tiers and the issues are, what is the basis for cutting off 80, for example, and not 200? What are the environment, what are the safety issues, what are the public health issues, what are the environmental issues that lead us to conclude that 205 is the right number, not 80, 300 is the right number, or a container of X size is the right number? It seems to me that there should be some sort of basis for those kinds of delineations. What we have and what's being proposed, to me, sounds like it could possibly be perfect, but I'm hearing from Jeff and that perhaps it's a little bit more arbitrary than it needs to be.
I
And a
think we
little
need
bit
to
more
have,
restricted than it needs to be.
yeah, and I think it may make sense to have a working session with staff and town board. Because I hear from them that there's a reason for doing this. I mean, it all started off not to, they asked Tom and Sabrina, where are there places in our town that we could do something like this? And I don't think that there were a lot of them.
Yeah, I'm sure.
But Chapel Crossing is a prime example. They've got a 2-point-something megawatt generator behind the office building that has all of North Shore. No, I keep thinking North Shore, whatever. Northwell, right? With diesel a belly tank and then diesel extra tanks right there, where someone skids, goes right into that diesel. That diesel tank is, there's a possibility of that spilling places.
Right.
Yeah, I mean, I guess the only question I guess I would pose to everyone would be just, this is more anecdotal, but we've seen like the emails and stuff. And I guess I appreciate everyone's efforts, but what I've heard and what's getting lost in the messaging is there are just some people, like the email from the engineer, who just seem to be very sorry for using this word, like hysterical about this, like where they're so against it, right? This idea of, oh, it's gonna get in our drinking water, or, you know, when we hear about you have to let the fire burn off and things like that. And I guess, I mean, my just 2 cents is maybe it's just a messaging issue, but there has to be a better way to sort of, you know, there's a lot of, I'm hearing a lot of cons and I'm not hearing enough of the pro side. That's just what I've heard, sort of, again, in conversations with people.
Try being a data center developer.
So can we just kind of refocus here? We can draft for you a letter, but you need to tell us what you would like to have it say.
Well, it seems to me that one of the themes is perhaps the proposals are too restrictive. And perhaps there should be something in the legislation that permits some sort of relief based on changing technology. If the town board's not going to be able to change the law every 6 months or every 3 years. Because it seems to me that these things are changing and more quickly than we can legislate, as usual.
Yeah.
So that seems to me to be one of the things.
Okay.
And to Stuart's point, the limitations and restrictions, whether, you know, however you want to call those, you know, I think they can be articulated in a very objective manner and weighed and you know, if as I've heard, 500 feet is the magic number for a residence separation from a tier 1, a tier 2, and however we define a tier 2.
Right.
You know, if it's still gonna be 80 or if it'd be 205
Well,
or
if
300.
one goes up to 205,
Right,
right, yeah.
exactly. So however, we might wanna suggest that the tiers are looked at in terms of more flexibility based on what the realities are out there right now. Never mind what the changes are.
And the separation of a tier 1 is different than the separation of a tier 2.
I would think so, I would
Right.
think so.
And I don't, you know, I don't understand why tier 1 is just restricted to the single family and 2-family homes. I could think of some wonderful commercial applications where it could probably be a good thing.
And I think there's some potential use for tier 2 as defined in a revised definition for some facilities in town. Again, I point to the Sunshine Home. They probably have some sort of diesel thing up there, but again, to Jeff's
How about the
point.
school districts?
Oh, the schools, absolutely.
Right. The school
And
districts?
it seems to me that at Greeley, you can place something that's more than 500 feet away from residences because they have a lot of property.
Yeah.
So you could do that. Is that okay?
I don't know, Mr. Chairman, listen, the 500 feet is a number that we came up as a best practice.
Right.
I don't want you to rely on that number as the magic number.
I understand that, and I guess that's really my point. In other words, it has been used as sort of a number at this point. It's the only thing that we have that I'm aware of. And all I'm suggesting is that we should be able to support that 500 one way or the other. If it should be 1,000, then it should be 1,000. If 200 is perfectly fine, then we should do that. My point is, it seems to me that we may have just pulled some of these numbers out in a fashion that, as things evolve, make little sense as we move forward. Or less sense, excuse me. Not
And
little
is the
sense.
500 based on an explosion? Is that where the separation?
It was based on fire safety.
Okay. Envisioning that it could explode.
It was based on fire, not necessarily air, and it was what we figured would be more manageable in relation to neighborhoods. Before it was determined that the town board did not want to subject neighborhoods in any event to battery energy storage.
And there might be, I don't know, perhaps Jeff, you have experience with this, but there might be some provisions or some steps that one could take even with a tier 2 to put an extra protection against groundwater in the event of a fire or a leak or suppression. You know, we've done that in other kinds of technologies, so perhaps that could be done. Yeah.
But a lot of that also is covered in the code, in the New York code here. So I was looking for, cause the greater you get, the larger onus is on you, it's more onerous what you gotta do. So, you know, there's specifications in here that goes through the whole thing, and then, you know, I know that Tom already deals with it, cause I talked to him about it, but even here's diagram for if you're doing it in your garage, right, what you're required to do, and specifications for clearances.
Is there a tier 2 anywhere in Westchester that we know of?
I'm sure there is. I don't know off the top.
Just to be curious to see what it looks like. And then how, you know, what's around it, what it looks like and stuff like that.
Are they not putting tier 2 in New York City in
Yeah,
some of the,
Yeah,
Well, I wouldn't even know what it looks like.
it's like,
it looks like a container,
Just like a container, that's
a
it?
shipping container.
Okay. So they're really
depending
not
on who
that
you
sexy.
are, it's white, or, I mean, it's, and like.
Or tan.
Yeah.
Yeah, so it's not that sexy, just a big box.
Yeah,
It's a big box.
Big box typically behind some fencing that you can't, you know,
An arborvitae.
There's one in Austining,
Where?
in Austining,
I'm asking.
Do you know where?
I believe. It's down by the waterfront.
Okay.
I believe.
yeah,
But
look to
there
your
is
point.
All right, so I have 3 comments right now. I can summarize them for you if you'd like.
I'll send you mine also, by the way.
All right, so the intention here, I think the town board gave you a deadline of March 19th to get comments back to them, so we can create a draft letter for you to review at your next meeting if you would like, based on your comments this evening, and if Jeff, you want to circulate comments to us.
Are they still continuing the public hearing to next week?
Yes, the public hearing has been continued to the 24th.
Okay.
Or to next week. No, I don't know if it's next week or it continues on the 24th.
Okay.
I think it was continued to the 24th.
Okay.
I could be wrong.
I'll look and see also.
Okay. I think that makes sense.
Okay,
Yep, good.
so do you wanna, direct us to write that?
Sure.
Draft that for you?
A motion for staff to direct a letter?
To draft.
No,
Draft a letter.
to draft.
Second?
All in favor?
Aye.
Okay. Excellent, thank you.
Sure.
So our next and last item are the minutes from February 3. Anyone, any changes?
No, I was good with these.
Yeah, I was too. All set?
Yeah.
Yes. If so, is there a motion to adopt the minutes of February 3?
Motion?
Second?
Second.
All in favor?
Aye.
Aye. And is there a motion to close the hearing, the meeting?
Motion.
Second?
Second?
All in favor?
Aye.
Aye. Okay, we're all set.